Good day everyone, I am Caubalejo from PCBet 22402A. Ang nasa na topic sa akin ay yung pinaka-last sa primary classification of obligations under the Civil Code, which is Section 6, Obligations with the Penal Clause from Articles 1226 to 1230. Unang article, Article 1226. Sinasabi dito sa article na to na nagkakaroon ng penalty in case na na-prove na guilty of fraud at saka kapag hindi nag-comply yung debtor sa obligation niya. Kapag sakali daw pong hindi masunod yung mga obligations, yung kaparusahan ay magbabayad siya ng damages and interest, pero babayaran lang daw po yun kapag tinanggihan ng creditor na bayaran yung penalty or di kaya napatunayang guilty yung debtor. Later on, mas maiintindihan niyo pa yung ibig pakahulugan nitong article na to. First, let's define principal obligation and accessory obligation. Principal obligation is one which can stand by itself and does not depend for its validity and existence upon another obligation, while accessory obligation is one which is attached to a principal obligation and therefore cannot stand alone. Magbibigay ako ng classic example para ma-identify natin itong dalawa. So for example, si Ana gusto niyang humiram ng pera sa bangko in the amount of 300,000 pesos. Yung may lalaman ng loan contract, yun yung example ng principal obligation kasi it is the obligation na napagkasunduan ng dalawang parties na dapat gawin or ma-fulfill. And then, yung bangko, syempre, kailangan niyang masiguro na makakabayad si Ana sa niloan niyang 300,000 pesos. So, nag-ask yung bangko na mag-issue si Ana ng real estate mortgage na land or building na almost in the same amount ng niloan niya. Yung land or building yung magiging collateral para sa niloan niyang 300,000 pesos. Or ito yung accessory obligation o additional requirement ni Ana to fulfill an obligation in line dun sa unang obligation o sa principal obligation. So, dito sa example natin, yung principal obligation is to pay 300,000 pesos. And yung accessory obligation is yung collateral or real estate mortgage na land or building. Basta, ang tandaan nyo lang dito sa principal and accessory obligation, kahit walang accessory obligation, present pa rin yung principal obligation kasi ito yung main obligation. While yung accessory obligation naman cannot stand alone because naka-attach siya sa principal obligation. And syempre, we must know the definition of obligation with penal clause and the penal clause itself. So, it says here, an obligation with a penal clause is one which contains an accessory undertaking to pay a previously stipulated indemnity in case of breach of the principal prestation intended primarily to induce its fulfillment. Sinasabi lang dito na in case of non-compliance, yung debtor obligado siyang magbayad ng penalty for damages or for interest. Bali, itong penal clause yung kakaharapin ni debtor in case di niya gawin yung obligation niya dapat niyang ma-fulfill. Next is the meaning of penal clause. It is an accessory undertaking attached to an obligation to assume greater liability on the part of the obligor in case of breach of the obligation. The obligation is not fulfilled or is partly or irregularly complied with, which means it is another obligation na naka-attach sa isa pang obligation na nangangailangan ng performance or simply in case na di nakapag-comply yung debtor, it requires a great responsibility in order to assure na i-fulfill ni debtor yung obligation niya. So next, let's discuss the purposes of penal clause. Para saan nga ba tong penal clause? Una, ito yung pinaka-main reason or function, o sabi nga dyan, yung general purpose of a penal clause. Kaya raw may penal clause ay para ma-ensure yung performance ng obligation ni debtor. nagkakaroon din ng knowledge and takot si debtor sa penalty na kakaharapin niya kung sakaling lumabag man siya. Nare-remind din yung obligor na i-fulfill yung obligation niya ng buo and in good faith. Itong first purpose na to ay tinatawag ding coercive purpose. Coercive means use of force or intimidation to obtain compliance. Kumbaga, nagagamit yung penal clause para mahalangan yung paglabag sa obligation kasi iisipin ni debtor na may kaukulang parusa kapag di niya na-comply yung obligation. Second purpose of penal clause is to substitute a penalty for the indemnity for damages and the payment of interest in case of non-compliance. Or tinatawag din tong liquidation purpose, meaning this is the act or process of eliminating. In short, ginagamit ang penal clause para pamalit bayad sa mga damages kung di man nagawa ni debtor yung obligation niya. Last purpose is to punish the debtor for the non-fulfillment or violation of his obligation, or tinatawag ding restrictive purpose. Yung penal clause daw po ay nakasulat sa kontrata na dapat i-punish yung obligor in case na di siya nag-comply sa obligation niya. Ibig sabihin lang nito na kapag yung dalawang parties nag-enter into a contract, silang dalawa yung magpo-fulfill ng obligations nila. And yung magiging reason lang ng punishment is either nag-fail na ma-fulfill yung obligation or lumabag sa obligation. So, for the example, Ken promised to construct the house of Barbie within 90 days for 1 million pesos. Tapos, sa contract nila, may naka-include na provision na sa kada araw na madedelay after ng stipulated na 90 days, magbabayad si Ken ng penalty na 10,000 pesos. This stipulation is an example of penal clause kasi ang obligation ni Ken na mag-construct ng bahay ni Barbie ay may penal clause. Sabihin natin natapos ni Ken makonstruct yung bahay after ng 95 days. Sumobra siya ng 5 araw sa napag-usapan. So, Ken will pay 50,000 pesos kasi 10,000 everyday na madali yung pag-construct ayon dun sa contract nila. So, 10,000 times 5 days na na-delay siya is 50,000 pesos. Meaning, yung bahay ni Barbie na 1 million pesos, para kay Ken, babawasan ng 50,000 pesos as penalty, kaya magiging 950,000 na lang yung babayaran niya. So, sabi ko nga, ang pinaka-purpose talaga ng penal clause is to ensure the performance na mag-comply si debtor sa kanilang obligation. So next, ito naman yung differences between penal clause and condition. Una, yung penal clause, as I have discussed earlier, ito yung accessory obligation, meaning another obligation siya na naka-attach sa main obligation, while sa condition is hindi. Kasi sabi nga last time sa nag-report ng meaning ng condition, it is future or uncertain event, meaning walang kasiguraduhan na mangyayari or depende pa sa sitwasyon. So next, therefore, the former may become demandable in default of the unperformed obligation and sometimes jointly with it, while the latter is never demandable. So, since the penal clause is an obligation, pwedeng i-demand to ng creditor in case of non-compliance of the debtor. And sabi din dyan, sometimes jointly, ibig sabihin, pwede ring both yung principal obligation and penal clause yung pwedeng i-demand or i-enforce, while sa condition is never demandable. Kasi nga, future and uncertain event yung condition, diba? And yung visa ng obligation is nakadepende sa kung ano pa yung condition. Penalty generally resolves question of damages. In the second case, when the purpose is reparation or compensation, the matter of damages is generally resolved. Reparation means action of repairing something, or it is something that is done or given to make up for damages. Meaning, in matter of damages, it is generally resolved. So, yung creditor, di niya na kailangan i-prove pa yung damages. Halimbawa dun sa in-example ko kanina about kay Ken and Barbie. Meron silang kasunduan na kapag na-delay si Ken sa pag-construct ng bahay, magbabayad ng penalty na 10,000 per day. na madedelay siya sa paggawa. So, may purpose rin ng reparation or compensation dun dahil nga yung creditor yung nagsasuffer kapag yung obligation ay di na-comply. Yung penalty yung i-consider na pamalit dun sa damages caused by the debtor. So, kapag ganun nga daw po yung purpose of penal clause, yung damages is solved na. Kasi yung penalty na mismo, yung mismong kabayaran. Next is when the purpose is punishment, the penalty does not resolve the question of damages. Kasi po, di ba once na punishment yung napag-usapan nyo, magkakaroon lang ulit ng obligation na dapat i-comply yung debtor, which is pwedeng mag-cause ulit ng non-compliance. At saka kapag ganito, pwedeng ma-recover yung damages bilang karagdagan dun sa penalty. Again, under Article 1226, the general rule is the penalty takes place the indemnity for damages and the payment of interest in case of non-compliance. Meaning, wala nang damages and interest kasi nga, yung penalty na yung ide-demand or i-enforce.
So next, obligations with penal clause strictly construed.
Obligations imposing penalties and forfeitures are strictly construed. Thus, it is well settled that sureties are only chargeable according to the strict terms of the bond. The terms of their contract are those which measure the extent of their liability. First, I will define some of the terms para mas madaling maintindihan. Construed meaning binibigyang pakahulugan. Yung forfeiture naman meaning giving up of something as a penalty for wrongdoing or yung pag-sacrifice or surrender. Yung sureties naman is the person who takes responsibility for another's performance of an undertaking or siya yung mananagot. Ibig sabihin lang nito na kapag obligation with penal clause, dapat na ma-explain yung obligations in terms of penalties para maging maayos at malinaw na yung party na di makapag-comply sa obligation niya, siya yung magiging liable. At kung ano man yung napag-usapan sa kontrata, ayun lang yung scope na pananagutan nila. So let's distinguish obligation with penal clause from conditional, alternative, and facultative obligation. There is some analogy between these obligations which sometimes serve to confuse them with each other. But these obligations are essentially different in nature and therefore meron silang ibang effects and consequences. First is obligation with the penal clause. I already discussed this earlier. It is the obligation na in case of non-compliance, kakaharapin ng debtor yung penal clause para ma-fulfill yung obligation niya. So, for example, Juan promised Kat to give a diamond ring, and if he fails to do so, he must give Kat 500,000 pesos. Di pwedeng i-excuse ni Juan na magbabayad na lang siya ng 500,000 pesos unless sinabi ni Kat na pwede niya na lang bayaran. Tandaan lang natin dito sa obligation with penal clause, merong principal obligation or yung main obligation kung saan yung accessory obligation ay naka-attach, which is yung penal clause. So dito sa case na to, yung principal obligation is to give Kat a diamond ring and the penal clause is 500,000 pesos. So next. Second obligation is conditional obligation. Natakil na rin to ng past reporters. In the conditional obligation, the existence of the obligation is uncertain, meaning the fulfillment is upon the conditions stipulated or yung effectivity ng obligation nakadepende sa future at uncertain event. Now, yung example naman natin kanina sa obligation with the penal clause ay gawin nating conditional obligation. Magiging si Juan, nag-promise siya na babayaran niya si Kat ng 500,000 pesos if he fails to give her a diamond ring. Bali kung mapapansin nyo, yung obligation ni Juan ay unknown. Walang kasiguraduhan, saka di pwedeng mag-demand si Kat ng performance ni Juan hanggang sa mangyari yung condition nila. At kung hindi man mangyari yung condition, yung obligation daw po ay kinoconsider in law na never to have existed. Meaning, sa example, sa conditional obligation, Yung obligation ni Juan ay babayaran niya si Kat kapag di niya natupad na bigyan si Kat ng diamond ring, and kapag nagawa niya, he don't need to pay Kat. Bali, yung obligation niya ay nakadepende dun sa condition. Third, in the alternative obligation, while there is only one obligation, two things are due alternatively, and the obligation may be satisfied by the performance of one of them. Dito, mas madali nating madidistinguish. For example, Juan promised Kat to give her either a particular diamond ring or 500,000 pesos. Dito sa alternative obligation, there is only one obligation. Two things are due alternatively. From the word itself, alternative meaning isa lang dun sa dalawa o higit pang mga available possibilities or choices. So, yung obligation masasatisfied by complying either isa lang dun sa options. Bali si Juan pwede siyang magbigay ng diamond ring o di kaya 500,000 pesos. Lastly is facultative obligation. There is only one thing due notwithstanding the right conferred upon the debtor to satisfy the obligation by substituting another in its place. So for example, Juan promised Kat to give a diamond ring, and if Juan desires, he can give Kat 500,000 pesos as a substitute. So dito, there is only one thing na napag-usapan pero pwede ring mag-substitute ng iba si debtor to satisfy the obligation. Pwedeng magbayad na lang si Juan ng 500,000 pesos kay Kat, pero tandaan nyo dito sa facultative obligation, dapat i-inform ahead ni debtor si creditor if ever yung substitute yung ibibigay niya na kung saan i-convert yung obligation niya dun sa isa. So dito sa facultative obligation, isa lang yung napag-usapan, pero merong binigay na right kay debtor na mag-substitute siya ng iba para makomply niya yung obligation niya. Let's discuss kinds of penal clause. First, as to its origin or point where something begins. Una, yung legal penal clause. From the word itself, legal or alinsunod sa batas, ito yung mga penal clause na provided by the law. Next is conventional. Nagkakaroon ng penal clause sa conventional kapag yung dalawang parties nag-enter into a contract and meron silang napag-usapan or agreement na meron silang penal clause. Next kind of penal clause as to its purpose are compensatory penal clause and punitive penal clause. Sa compensatory penal clause, kanina na-discuss ko to sa pangalawang purpose ng penal clause, sa to substitute a penalty for the indemnity for damages and the payment of interest in case of non-compliance. Masasabing compensatory penal clause when the penalty takes place of damages. Pag punitive penal clause naman, from the word itself, punitive, there is a punishment. As I have said earlier sa pangatlong purpose of penal clause, na layunin ng penal clause na maparusahan yung debtor in case of non-compliance. Third, as to its dependability or effect. Pwede siyang subsidiary or alternative penal clause and joint or cumulative penal clause. Kapag subsidiary or alternative penal clause, it is when only the penalty can be forced. Kapag sinabi namang joint or cumulative penal clause, dito naman yung both principal obligation and penalty yung pwedeng ma-demand or ma-enforce ni creditor. Example ng subsidiary or alternative penal clause. John obliged himself to give Marina a specific car on October 25. If he fails to do so, John will pay 100,000 pesos as a penalty. Ibig sabihin, in case na di mabigay ni John kay Maria yung specific car on October 25, yung 100,000 pesos lang yung pwede niyang ma-demand kay debtor. Kasi kapag subsidiary or alternative penal clause, yung penalty lang yung pwede niyang i-demand or i-enforce. And kapag joint or cumulative penal clause naman, John obliged himself to give Marina a specific car on October 25. If he fails to do so, John, in addition to the car, must pay Marina 100,000 pesos. So, kapag joint or cumulative penal clause, in case of non-compliance, pwedeng mag-demand si creditor yung una, yung principal obligation, and syempre, yung penalty. From the word itself nga, joint or cumulative, meaning pinagsama or combined. Next. So, para mas maging malinaw tong Article 1226, let's discuss liability for penalty, damages, and or interest. So, first, penalty substitutes for damages and interest. As general rule nga po, in obligation with penal clause, the penalty takes place of the indemnity for damages and the payment of interest in case of non-compliance. Meaning yung penalty yung magiging kabayaran dun sa damages or interest. Next is penalty and interest enforceable. Sabi daw po sa batas, pinapayagan sa isang kasunduan na mayroong penalty bukod sa interest. Dapat nakasulat dun sa kasunduan na yon yung penalty and interest ay magkaiba na pwedeng i-demand ng magkahiwalay. Third is penalty, damages, and interest enforceable. In addition to the penalty, pwede ring mabawi ni creditor yung damages and interest kapag una, napagkasunduan ng dalawang parties, or yung pangalawa kapag tumanggi si debtor na bayaran yung penalty, or last, kapag napatunayan guilty of fraud si debtor sa pag-fulfill ng kanyang obligation. So for the example, SpongeBob promised to deliver a specific car to Patrick. Tapos nakalagay sa contract nila na there has a penalty in case of non-compliance. SpongeBob would have to pay a penalty of 20,000 pesos, and then si SpongeBob di niya na-deliver yung car, and dahil doon si Patrick nagsuffer siya ng damages in the amount of 15,000 pesos. Let's say ibebenta pala ni Patrick yung dapat na sasakyan na ma-deliver ni SpongeBob. But dahil sa negligent act ni SpongeBob, nawalan ng kikitain si Patrick or tinatawag ding loss of future earnings. Yung damages din kasi, hindi lang siya yung physical suffering like injuries and pains. Pwede rin yung katulad ng sinabi ko or in mental issues. For instance, yung sinabi ko kanina na nawalan ng future earnings si Patrick, diba? Pwedeng dahil doon, ma-depress si Patrick, and because of that, magkakaroon siya ng expenses sa hospital, like medicines. So, going back sa example, in this case, the penalty na 20,000 pesos ay dapat mabayaran. Pero hindi pwedeng ma-recover ni Patrick more than dun sa napag-usapang penalty or more than dun sa 20,000 pesos. Kahit na-approve niya pa na 25,000 pesos yung mga damages na nasuffered niya. Kasi nga, una, pwedeng i-substitute yung penalty para pamalit bayad sa mga damages na 15,000 pesos. Or unless, meron daw silang napag-usapan na kung saan pwede ring makuha ni Patrick yung mga damages kapag na-prove niya. At kapag tumanggi naman si debtor, which is SpongeBob dyan sa example natin, na bayaran yung penalty, pwedeng makuha ni Patrick yung legal interest. And yung interest na yun, yung nagre-represent sa bagong damages dahil sa di pagbayad ni debtor sa penalty. And if SpongeBob is guilty of fraud sa pag-fulfill sa kanyang obligation, he is also liable sa mga damages na na-cause alinsunod nga sa Article 1171, responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Kailangan lang patunayan ni creditor or ni Patrick na guilty of fraud si SpongeBob para ma-recover niya yung penalty. Yung last is requirement to make penalty enforceable. Ito rin yung last paragraph sa Article 1226. Ibig lang sabihin nito na yung penalty na nakasaad sa contract, demandable lang siya kung mayroong paglabag sa obligation and hindi salungat sa batas, sa moral, good customs, public order, or public policy according sa Article 1306. Balikan lang natin tong Article 1226 for the summary. Tandaan lang natin na sa Article 1226, yung general rule in obligation with the penal clause is pwedeng isubstitute yung penalty para pamalit bayad sa damages and interest. Pero meron siyang exemption, ibig sabihin, pwede mo pa rin i-demand yung damages and interest. First exemption is if there is no stipulation to the contrary, meaning walang salungat na napagkasunduan, or pag merong inexpress sa agreement. Second, kapag nag-refuse si debtor na bayaran yung penalty. And last, kapag napatunayang guilty of fraud si debtor sa pag-fulfill sa kanyang obligation. So, yung last paragraph nga po dyan, na discuss ko na kanina, yung requirement para maging demandable yung penalty is kapag may paglabag sa obligation at kapag yung penalty ay hindi salungat sa batas, sa moral good customs, public order, or public policy. O dapat sang-ayon siya sa provisions of the civil code. So, next article naman tayo. In this provision, penalty is not a substitute for performance of obligation. Di pwedeng basta bayaran na lang ni debtor yung penalty instead of performing the obligation. Kaya naglagay ng penalty, di ba? Sabi nga sa general purpose ng penal clause is to secure compliance of the obligation. Kung i-allow natin si debtor na bayaran na lang yung penalty and di niya nagawin yung obligation niya, then magiging alternative na lang yung obligation. Pwede daw ma-exempt ni debtor yung sarili niya sa di pag-fulfill ng obligation kapag meron siyang karapatan na malinaw na provide para sa kanya.
So, para mas maintindihan pa tong Article 1227, next slide is...
Paano nga ba natin masasabing subsidiary or joint yung penal clause? As a general rule nga ng subsidiary penal clause, di pwedeng mag-demand si creditor ng fulfillment ng obligation saka penalty at the same time. So, bali, yung penal clause, subsidiary lang siya or tinatawag ding alternative, meaning less important or secondary lang. So, first, where there is performance. Kapag na-fulfill na ni debtor yung obligation niya, di na pwedeng i-demand ni creditor yung penalty except when this right has been clearly granted. And second, when there is no performance. Like what I have said a while ago, kapag merong na-commit na fraud sa part ni debtor, pwedeng i-demand ni creditor yung penalty as well as damages for non-fulfillment according din sa Article 1226. Dito naman, when penal clause is joint. Kung natatandaan nyo, na-discuss ko kanina sa kinds of penal clause dun sa as to its dependability or effect. Yung subsidiary, which is yung last slide, nakaka-discuss ko lang, and itong joint penal clause. Sa joint penal clause, pwedeng i-demand ni creditor yung obligation plus yung penalty. So, may karapatan nga si debtor na bayaran na lang yung penalty instead na gawin niya yung obligation niya when this right has been expressly reserved for him. Note lang dito sa word na expressly, meaning dapat malinaw na nakasaad talaga sa stipulation o sa agreement ng both parties na meron siyang right to do so. But with the respect to the creditor, meron siyang karapatan to demand both performance and penalty when this right has been clearly granted him. Ibig sabihin, di katulad sa debtor na kailangan expressly reserve yung right niya. Dito, kahit implied lang or hindi siya direct na ipinahiwatig, pwedeng i-demand ni creditor yung principal obligation as well as the penalty.
So, for the example, ito na rin yung pinaka-summary ng Article 1227.
Gerald obliged himself to construct the house of Julia. And dapat matapos niya ito sa loob ng 3 buwan. Otherwise, Gerald is going to pay Julia 100,000 pesos as penalty. So, ano-ano nga ba yung mga rights and obligations ng dalawang parties? First, si Gerald, hindi siya makakapagbayad lang ng 100,000 pesos na multa tapos di niya na i-construct yung bahay ni Julia unless meron silang agreement na binigyan si Gerald ng option or ng right. Kasi sabi nga dun sa first sentence ng Article 1227, The debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved for him. Si Julia naman hindi siya pwedeng mag-demand kay Gerald na i-construct yung bahay at the same time, bayaran siya ng 100,000 pesos unless napag-usapan din sa agreement nila. It is based naman sa second sentence of Article 1227. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted him. Now, kapag nagdemand naman si Julia ng fulfillment of obligation, but the performance became impossible due to Gerald's fault and without the fault of Julia, so pwede mag-ask si Julia kay Gerald ng payment for penalty. Ito naman ay based sa last sentence ng Article 1227. It says here, however, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. So let's go with the next article, 1228. Sinasabi lang dito na kailangan ng proof of actual damages ni creditor para ma-enforce yung penalty. So, penalty demandable without proof of actual damages. Sa obligation with penal clause, ang kailangan lang patunayan ni creditor para ma-enforce yung penalty is yung paglabag lang ni debtor sa kanyang obligation. Di na kailangan pang magdagdag ng ebidensya para mapatunayan lang na lugi at na napinsala si creditor. Sa katunayan nga daw po, yung dahilan ng pag-aayos is yung penalty para maiwasan yung mga requirement or demand and other difficulties sa mga involved sa case. Pwede rin mag-demand ng penalty si creditor whether he suffered damages or not, pero he cannot recover more than the stipulated penalty kahit na pinatunayan niya yung amount na damage ay lagpas pa dun sa penalty. Kaya dito sa susunod na bullet, damages recoverable in addition to penalty must be proved. Dito daw sa Article 1228, yung penalty is fixed by the parties para i-substitute in the indemnity or yung bayad for damages. Alin man dun sa tatlong exceptions sa Article 1227, kung yung damages daw ay i-recover in addition to sa penalty, kailangang i-prove ni creditor yung amount ng damages na talagang nag-suffer siya sanhi nung paglabag sa obligation ni debtor. So for example, Michael entered into a contract with the building contractor Raymond to build a resort-type residential community at his hacienda. Tapos sa kanilang agreement, dapat matapos ni Raymond yung project in 12 months. Kasi kung hindi, magbabayad siya ng penalty kay Michael ng 1 million pesos sa kada buwan na madedelay siya sa paggawa ng project. Tapos, na-fail si Raymond na matapos yung project within sa specified time frame na pinag-usapan. Kaya ang nangyari, hindi nakapag-start si Michael na magbenta ng properties niya sa bago niyang residential community. Sa case na to, hindi kailangan i-prove ni Michael sa court yung actual damages na nakos ng paglabag sa obligation. Ang kailangan lang niyang i-prove na na-failed sa pag-comply o pag-fulfill ng obligation si Raymond na di niya natapos yung project within 12 months as stipulated sa kanilang contract. Kaya dapat mabayaran ni Raymond yung penalty na 1 million kada buwan, depende kung ilang buwan siyang na-delay. Next is penalty and liquidated damages distinguished. In jurisdiction daw po, yung penalty and liquidated damages ay walang pinagkaiba kasi once na lumabag sa contract yung isang party, yung penalty or yung liquidated damages yung babayaran. Yung pinagkaiba naman ng penalty and liquidated damages, sa penalty ito yung fixed amount na ginagamit as punishment. Diba sabi ko nga dun sa purpose ng penalty ay para ma-ensure yung performance or maiwasan yung paglabag na napagkasunduan sa kontrata. While liquidated damages, ito naman yung estimated amount ng total ng nangyari sa paglabag sa kontrata. Kumbaga, ito yung kabayaran sa mga napinsala. Basta tandaan nyo lang dito na pareha silang amount na napagkasunduan ng dalawang parties. Yung liquidated damages ginagamit para sa mga pinsala na maaaring malabag sa kasunduan. Ito yung calculation ng actual loss ng creditor kapag nagkaroon ng paglabag sa contract. Yung penalty naman ginagamit para ma-force na ma-fulfill yung obligation which is naka-indicate sa contract na in case na di mag-comply sa obligation, yung penal clause yung dapat bayaran. Second to the last article sa Section 6 obligation with the penal clause is Article 1229. This provision talks about kung kailan ba yung penalty na napag-usapan ng both parties ay pwedeng i-release ng court. According dyan sa Article 1229, una, kapag yung principal obligation has been partly complied with the debtor. Sunod naman kapag irregular na kinomply ni debtor. And when the penalty is iniquitous or unconscionable, even if there has no performance at all. Iniquitous or unconscionable meaning it is morally wrong or hindi tama. Sa mga susunod na slide, mas maunawaan nyo pa yung sinasabi dito sa Article 1229. So, maaari niyang mabawasan ng korte yung penalty when there is a partial or irregular performance. So, for example, si Juan, nag-promise siya na ma-deliver niya kay Marie yung 10 bottles ng wine on December 25. Kapag nag-fail siya na gawin yung obligation niya na ma-deliver yung 10 bote ng wine, magbabayad siya ng penalty na 5,000 pesos. Tapos, ang na-deliver lang ni Juan is 9 bottles out of 10. So, kulang siya ng isang bote lang. So, si Marie, hindi siya pwedeng mag-demand ng penalty na 5,000 pesos. Instead, it will be reduced by the court kasi meron yung partial or irregular performance na nangyari. Kasi yung penalty daw should be more or less proportionate sa lawak ng paglabag sa kontrata o dun sa damages suffered by the creditor. Meaning, yung penalty, depende siya sa kung gaano kabigat or kalawak yung nalabag. Diyan kasi sa example ko, lugi naman si Juan kung magbabayad siya ng 5,000 pesos, isang bote lang naman yung di niya nabigay. Kaya dun mangyayari yung pagbawas ng penalty ng korte. Next naman, penalty may be reduced by the courts kapag yung penalty na napagkasunduan ay immoral or unfair, basta something na hindi nararapat or hindi tama, even if there is no performance at all. So, halimbawa, Juan promised to pay Marie 10,000 pesos on December 25. Kapag na-fail naman siya sa obligation niya, magbabayad siya ng 50,000 pesos. So, kapag hindi nakapagbayad si Juan ng 10,000 pesos on December 25, di pwedeng mag-demand si Marie ng penalty na 50,000 pesos kasi it is iniquitous or unconscionable. So, the penalty may be reduced by the court kasi ang layo ng gap ng principal obligation at nung penalty. Sino ba yung magsasabi kung yung penalty is iniquitous or unconscionable? Actually, it will be addressed sa mahusay na paghuhusga ng korte. So, yung korte yung magde-decide kung yung penalty is iniquitous or unconscionable, considering several factors like kung ano yung type, lawak, saka purpose ng penalty. Tinitingnan rin ng korte yung nature of the obligation, saka yung paraan ng paglabag, at kung ano yung kahihinatnan ng paglabag na yun. Ilan lang yun sa mga kino-consider ng korte para matukoy na iniquitous or unconscionable yung penalty. So, last article for Section 6 obligation with the penal clause, the Article 1230. The nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause. Ibig sabihin lang niyan, di ba yung penal clause is naka-attach sa principal obligation kasi di ba yung penal clause is an accessory undertaking na naka-attach or follows the principal obligation at hindi daw vice versa. And yung reason kung bakit yung penal clause ay naka-attach sa principal obligation kasi para ma-enforce at magawa ni debtor yung napagkasunduan sa kontrata. Ano nga ba yung effect ng nullity ng penal clause at ng principal obligation? So kapag ang penal clause becomes unlawful, walang kinalaman or di affected dun yung principal obligation, bali valid or demandable pa rin yung principal obligation. At kapag yung principal obligation naman yung naging null or void or to be treated as invalid, the penal clause is void also because penal clause cannot stand alone without the principal obligation. So for example, sa effect of nullity of the penal clause, Mark obliged himself to construct a house for Justin within 3 months. In case na di ma-perform ni Mark yung obligation within sa napag-usapang date or period, bibigyan ni Mark si Justin ng 10 kilograms pack ng shabu. In this case, legal or valid yung principal obligation na mag-construct ng house for Justin within 3 months. Pero yung penal clause is null or void. Diba, sabi nga sa effect of nullity of the penal clause, hindi maapektuhan yung main obligation, meaning demandable pa rin yung obligation. Kaya ang mangyayari, may principal obligation pa rin, pero wala ng penal clause. Kasi nga, yung shabu is unlawful. So, example naman sa effect of nullity of the principal obligation, Justin obliged himself to give Mark 5 kilograms pack of shabu. And in case of non-compliance, 400,000 pesos will be forfeited from Justin. Dito, yung main obligation is legal kasi illegal yung shabu, but yung penal clause na 400,000 pesos ay valid. Pero diba nakadepende yung nullity ng penal clause sa principal obligation. At sabi ko rin kanina na kapag invalid yung principal obligation, pati yung penal clause magiging invalid. So tandaan nyo lang dito sa Article 1230, kapag yung penal clause is null or void, hindi maapektuhan yung principal obligation. Bali, pwede pang i-demand yung principal obligation. At kapag yung principal obligation naman yung null or void, pati yung penal clause is magiging void na rin. Kasi nga, yung penal clause cannot stand alone kapag walang principal obligation. And that's all for my report. Section 6, Obligations with a Penal Clause from Articles 1226 to 1230. Thank you for listening.